it's 10:30, so... Right. Yeah, he was here 1 minute. Start the meeting. Sorry. Okay. Welcome everybody to this meeting of the LRB of 13th of March. I can confirm the meeting has been properly called and is quorate. Please can I ask members firstly to appoint a chairman for the meeting? Councillor Geddes.
I would move Councillor McKee be invited to chair this meeting if he's prepared to accept the nomination.
Councillor McKee.
Right, good morning, gentlemen, ladies and gentlemen. Welcome to this meeting of the Local Review Body, Wednesday, 13th of March. No apologies. Any declarations of interest? No, thank goodness. Claire, you want to take us through the first item, please? Before you start, I'd like to remind everybody present that this meeting will be recorded and the recording will subsequently be made available for public listening. Thanks, Claire.
Thank you, Chairman. I can confirm that we have 3 notices of review for consideration at this meeting. The first being item 4 on the agenda, Galloway Lodge, 2 Southview Lodges, Kippford, Dalbeattie, refusal of planning permissions for demolition of existing lodge and erection of replacement dwelling house. In your papers you have the key documents being the notice of review dated 19th of December, the report on handling, observations of the appointed officers, the response from the applicant's agent, the planning application form, the decision notice from Dumfries and Galloway Council, plus relevant extracts from Dumfries and Galloway Structure Plan and Statutory Local Plans, as well as photos of the application site and the locality. The grounds for refusal in this case are on pages 122 to 123, being that the application fails to demonstrate that a new dwelling house is essential at this location for the needs of agricultural or any other use requiring an appropriate rural location and would therefore represent unjustified housing development in the countryside. The proposal is therefore considered to be contrary to the requirements of Dumfries and Galloway Structure Plan Policy D4 and Statutory Local Plan General Policy 15. In the papers, the requested method of determination is on page 15, where the applicant has requested that the review be dealt with on the basis of further written submissions and on the basis of 1 or more hearing sessions. The grounds stated in the notice of review on pages 18 to 24 are in summary that there is established long-term residential usage at this location. Other houses in close proximity have no restricted usage. There is an established boundary of residential development within which the applicant's proposal sits. Every application should be considered on its own merits and precedent should not form part of any assessment. The planning policy cited is aimed at new development. Application is for the redevelopment of an established house. You also have further comments of interested parties, being the comments of the road officer on page 33, comments of Scottish Natural Heritage on pages 35 to 36, and comments of the appointed officer, David Sutty, Service Manager Development on pages 45, as well as already mentioned, you have the key development plan policies. So the main issues for the local review body to consider are, does the proposal conform with the relevant development plan policies, and critically, in terms of the structure plan policy D4, 2, 3 and 5, has it been satisfactorily demonstrated that either the proposal represents the replacement of a habitable dwelling house by a new house within the same curtilage, the site falls within a recognised small building group identified for further housing, or is there an essential and not merely desirable need that house be sited at this specific location for the purposes of agricultural or other use requiring an appropriate rural location in the countryside? Are there any material circumstances which would indicate that a planning permission should be granted as an exception to policy? And what weight, if any, do the LRB wish to give to the comments made by the applicant's agent that there has been a long and established long-term residential usage at this location, and that the proposal is for the redevelopment of an established house, bearing in mind that the existing building was only ever approved as a holiday lodge and is subject to an ongoing occupancy restriction? So, having outlined the documents within the members' papers, and it falls to the LRB to determine whether it has sufficient information to consider the review, it is confirmed that there will be no representations from any party heard today. The LRB has the following options available, and that it can decide that it has sufficient information before it to determine the review today. Request further information in the form of written representations. In doing this, the LRB would have to state precisely what information it is seeking and who would provide it. Resolve to hold a hearing, again specifying who will be invited to speak and on what matters. Resolve to hold a site visit, accompanied or unaccompanied. This can be done in conjunction with any of the above, but would obviously not allow a decision to be made today. If the LRB resolves it has sufficient information and that no further procedure is required, then under section 43A.15, the LRB has the full powers to uphold, reverse or vary a determination, and section 43A.12a requires that the decision notice includes a statement of the terms in which the planning authority has decided the case reviewed. You have an independent planning advisor here at your meeting. She is here to assist. It is confirmed that she has not had any involvement in the case, is not the case officer or the appointed officer. She is purely here to provide independent advice as needed on matters of planning policy, law or process of the local review body. So if members are clear and no further clarification is required, I will ask the chairman now to lead the debate and for the LRB to in the first instance determine if they have sufficient information before them.
Thank you very much, Claire. Well, on that, Councillor Geddes.
I would suggest that we have sufficient information before us today to allow us, to consider and to determine this particular application.
Sorry, we'll go through a section at a time, and if you have any questions, individual sections, just raise them as we go through. Starting section 1, notice of review dated 19th of December. Councillor Thompson.
Could you indicate the page numbers, please?
Let's start on page 7 through to page 24. In that section, go to section 2, report on handling, page 25 through to page 41. There's an issue regarding the occupancy condition, which is mentioned in 1.1, and it refers you to paragraph 1.5, where the relevant planning history is laid out. There seems to be a bit of debate about whether there's actually a condition on this house or regarding occupancy. Could you bring us up to date on that, please, Mrs. Kay?
Thank you, Chair. The existing chalet on the site has an occupancy condition, and that's been referred to in paragraph 1.1, and it talks about it under the reference at that point. But the proposal does not include a requirement for an occupancy condition. So the proposal is purely as described: demolition of existing lodge and erection of a replacement dwelling house at Galloway Lodge, 2 Southview Lodges, Kippford. So when you turn to the paragraphs at 1.5, that is the background history to the site itself, but also the adjacent properties. Thank you.
It's just that the 93P/2/0107 and the following one, full plan of permission for a deletion of condition 2, and the 92P/20391, it was approved that considered difficult to sustain justify retention of an occupancy restriction, given that the original chalet dwelling did not have one imposed. There seems to be a bit of dubiety, I think, when the planning permission was originally put on. Could you just clarify that, please?
Thank you, Chair. Yes, I can. The original permission was for 4 chalets and an occupancy, including the application site, an occupancy condition was attached to that. But for the 5th site, which is 88P/20335, this was approved subject to conditions. The site is immediately adjacent to the 4 chalets referred to above. An occupancy condition was not attached to this permission. And then it says due to human error. Then if you refer back to 93P/2/0107, an application was received for an extension and they put a condition on the extension only to try and address the human error of the 1988 application. But at that point, it was recognised that was not reasonable to do that because you couldn't have the main building having open occupancy and the extension having holiday occupancy. So that is the history behind that. And that is for a separate, standalone, adjacent, different chalet.
Anybody else any questions on that? Councillor Nicholl?
Just for clarification, Mrs. Kay, one of these chalets has got no occupancy restriction, but the rest have. Is that what you're telling us?
Yes, I confirm that. And that is historically how the development occurred in the late 80s, 1980s. So an application came forward for the 4, and an occupancy condition was attached to it. And this application site is one of those 4. But a further one came forward, and at that time, due to human error, a condition wasn't attached.
Okay, any more questions in that section? No. All right, observation of the appointed officer, page 43 to 45. Response from the applicant's agent, page 47 through to page 51. Okay, item 5, page 53, planning application form dated the 31st of July. Page 55 through to 118. No questions. Item 6, page 119, decision letter from Dumfries and Galloway Council, page 119 to page 123. No. Section 7, relevant extracts from Dumfries and Galloway structure plan and Stuart local plan, page 125 to 130. Okay. And section 8, photos of the application site and the locality. Do you have pictures that you can show? Right, we have pictures that we can put up on the screen, hopefully.
Okay, obviously, you note that I'm actually turning the pages and showing you the photographs as they appear in the report.
Right, thank you very much. Any comments to make? Councillor Geddes?
Well, I would think so. In my opinion, the case officer, Mr Clapworthy's report is well founded in the various issues and principles in question, and I am particularly impressed and swayed with Mr Sutty's response, as it were, in the relevant reply, setting out and reinforcing exactly why he feels, in fact, that the conclusions arrived at by the case officer are, in fact, the correct conclusions. And in these circumstances, without wishing to truncate debate, my view is that I would not be prepared to grant the application to overturn the decision that's previously been reached in relation to this application.
Thank you. Councillor Nichols, you want to second it? Anybody otherwise minded? Right, the decision is to uphold the decision of the officers. Claire, can I give it to you?
Thank you, Chairman. I can confirm that the local review body are upholding the decision of the appointed officer to refuse planning permission for Galloway Lodge, 2 Southview Lodges, Kippford, Dalbeattie, refusal of planning permission for demolition of existing lodge and erection of replacement dwelling house on the same grounds as details in your papers, being that the application fails to demonstrate that a new dwelling house is essential at this location for the needs of agriculture or any other use requiring an appropriate rural location, and would therefore represent unjustified housing development in the countryside. Proposal is therefore considered to be contrary to the requirements of Dumfries and Galloway Structure Plan Policy D4 and Statutory Local Plan General Policy 15.
Thank you very much, Claire. Can we now move to item 2, notice of review, refusal of planning permission for demolition of existing dwelling house, erection of a replacement dwelling house and detached garage, and installation of septic tank and soakaway at Torwood Lea, Anwoth, Gatehouse of Fleet. Claire, do you want to take us through again, please?
Thank you. We have a change in planning advisor for the next 2 items. Yes. Thank you very much. Item 5, Torwood Lea, Anwoth, Gatehouse of Fleet, refusal of planning permission for demolition of existing dwelling house, erection of replacement dwelling house and detached garage and installation of septic tank and soakaway, 12P20222. Again, you have the following key documents in your papers, being the notice of review, report of handling, observation of the appointed officer, response from the applicants, planning application form, decision notice, relevant extracts from relevant plans, and the photos of the application site. The grounds for refusal in this case are that the proposed, by virtue of its elevated siting, massing, scale, height and proportions and general design, citing the design, fail to accord with the character and appearance of the Anwoth small building group, particularly the group of buildings adjacent to the application site. The proposal is therefore contrary to Structure Plan Policies D36 and Stewardship Local Plan General Policies 7 and 16. The requested method of determination on page is 144. The applicant has requested that review be dealt with on the basis of an assessment of these review documents only, with no further procedure. The grounds stated in the notice of review on pages 147 to 177 are in summary. The proposed dwelling house would be visually and environmentally low impact and would be of materials, form and location that is intended to become part of the landscape. Of the 11 buildings in the Anwoth small building group, the proposal would be the fourth largest and fifth highest. The design is based on the shape of the traditional rural cottages with elongated rectangular footprint. Their aim is to design and build a house that fits within the character and appearance of the Anwoth small building group. Their design statement includes details of their approach to ensure they comply with current guidelines regarding location, prominence and sustainable design. The further comments of interested parties being the comments of the road officer on page 187, comments of Scottish Water on page 189 to 190, and the comments of appointed officer on pages 201 to 202. Again, you have the relevant development plan policies on pages 183. And so the main issues for the local review body in this case are to consider: does the proposal conform with the relevant development plan policies, and in particular structure policies D36 and stewardship local plan general policies 7 and 16 in respect of the elevated position of the chosen location position within the site relative to the other properties in the small building group and the proposed design materials in that location? Are there any material circumstances which would indicate that planning permission should be granted as an exception to policy? So again, having outlined the documents within the papers, it falls to the LRB to firstly determine whether it has sufficient information to consider the review, and again it is confirmed that there will be no representations from any party that will be held today. Planning advisor is present at your meeting. He is here to assist. He has not had any involvement in the case, not the case officer or the appointed officer. He is here purely to provide independent advice as needed on matters of policy, planning policy, law or process to the LRB. So if members are clear and no further clarification is required, I will ask the chairman now to lead the debate and for the LRB in the first instance to determine if it has sufficient information before them.
Thank you very much, Claire. Are we agreed that we've got sufficient information in front of us? Thank you very much. Right, can we go to notice of review, page 137 through to page 177? I notice a bit of a complication here. There was a planning permission given for the demolition, but there was no planning permission. It was only planning permission in principle. A new application to be put in for detailed matters. Is that the situation, Mr. Sutton? You want to clarify that, please?
Yes, thank you, Chair. Basically, the history of the site is that there is and remains a valid planning permission in principle on the site. So that has established the principle of a new house going on the site. However, you will note that you can't actually develop a planning permission in principle. You need to either submit what used to be called reserved matters. It's the matters which are specified in the conditions of that planning permission in principle as a further application, or indeed, as the applicant has done here, submit a further application for full planning permission. So this is not an application for the matters which were reserved by that. This is a full planning application. So in other words, you're considering this afresh, but a material consideration is the fact that there is a planning permission in principle still valid on the site.
Thank you. I should have asked you, have you any photographs to show us?
Yes, certainly, Chair. I'll just run through those for you. These are the same ones that you have in your papers. These will be on page. So they start on page 295. So the first one basically shows you the existing house which is on site. It's still retained its structure, but it's clearly not habitable in its present condition. And panning round from that site, you can see that already some works have taken place to form an access further up into the site. And that's looking back down towards the access, the military road. So as you'll see in your papers, that property would be completely flattened, but the proposed house wouldn't be sited on the footprint of the existing building. It would be further up into the field. So this is the area here in which the proposed house would actually be built. And the case officer's got another slide just panning round from that same photo. That's looking down into Anwoth, down the access, the military road, and the building that would be demolished is there on the left. And the next photo she's got just turns round and looks up the military road with the building to be demolished on the right. And this is a view that she's taken in the village, so you can see the new property, Slake's Cottage, you can see in the centre there, and some of the other traditional ones. The application site is more or less in the centre of that slide, as I understand it. The existing building is hidden behind trees, so that, as I understand it, it sits somewhere in about there, and the application site is sitting more or less there. And that's a further shot that the case officer's taken. So again, as I understand it, the site where the house would be going would be somewhere in around there, where the existing building that would be demolished is currently screened by the trees.
Councillor Nicholl.
Yeah, a couple of points of clarification. Could you go back 2 or 3 slides, please, David? That would do. No, either that one or the one before it. So that would be roughly the site of the proposed site of the property. Is that correct?
Yes, I mean the plans which you've actually got will show you the location. The best one to look at is probably on page 219. That actually has the outline of the house to be demolished, and then you can see the house that would sit behind it. Another one which is quite useful is on page 222, which give you the sections through the site, so you can see that the proposed house is actually up on this area here, you see in the slide, in relation to the building which would be demolished, which is on the left.
Could I just ask, on page 156, it shows Torwood Lea, and then the thing at the bottom here, it shows buildings. Presumably that is a proposed building for Torwood Lea.
I'm assuming so, because obviously you have the existing situation shown on the location plan for it, yes.
That's okay.
Questions in that section? Section 2, report on handling, page 179 through to 197. Section 3, page 199, the observation of an appointed officer to 202. Section 4, report from the applicant's agent on the observations of the appointed officer, page 203 through to page 209. Planning application form, section 5, page 211 to page 247. Okay. Section 6, decision letter from Dumfries and Galloway Council, dated 1st of November, page 249 to page 253. Section 7, relevant extracts for Dumfries and Galloway structure plan and the Stewart Lea local plan, pages 255 to 291. Oh, so, Councillor Nicholl.
Yeah, thanks, Chair. On page 276, Mr. Sutty, Torwood Lea is shown as the small building, presumably the existing building that's there. The one next to it was shown as a site in the small buildings group. Is that the one that has been developed?
Yes, just for clarification, it's actually Anwoth as the small building group, not Torwood Lea. But yes, the building you see in the centre of the slide there is one called Slake's Cottage, and that's the one where you see the top of the three diamonds that was identified due to its history.
Okay, we'll go to section 8, the photos I've already seen up on the screen, the application site, pages 293 to 299. Do you want to raise any issues on the matter? Okay, I would suggest that we uphold the decision of the planning officers, and that by virtue of its elevated siting, massing, scale, height, proportions and general design, the design would fail to accord with the character and appearance of Anwoth small building group, particularly a group of buildings adjacent to the application site, and suggest that the proposal is therefore contrary to structure plan policies D36 and Stewart Lea local plan general policies 7 and 16. Councillor Geddes.
Well, can I suggest, sir, looking at the grounds of refusal in detail, I mean, we're talking there about the first one that, by virtue of its elevated siting. Well, it seems to me, sir, that the applicants have made it abundantly clear in their submissions as to why they feel, in fact, that it's necessary to have a somewhat elevated siting, and the proposed elevated siting that they have gone for. Let me say in conceptual terms, Chairman, I've got a very considerable degree of sympathy for what these two applicants are endeavouring to achieve. Not only that, I think in this particular setting, the design would be certainly at variance with what's there at the moment, but I don't see it, as being eye-jarring as a consequence. I think in that particular setting, in the proximity of the woodland, etc., it could justify, and I stress could justify, a rather different design from, for instance, the last property which has been provided on site. And we've talked as a planning authority over the last number of years about perhaps being a bit more innovative. Maybe this is a case where we should be looking at that very possibility. As I say, I particularly like the idea that the applicants are seeking to work from home. They're talking about a house which it will do more than tick the boxes as far as I'm concerned, from carbon issues, etc. And in this particular location, I think there might just be. I would welcome, obviously, hearing the views of your colleagues and yourself, Chairman, but I certainly would not be tempted to refuse the application out of hand. And I wonder, in fact, if there's maybe not just the possibility of some form of compromise being attainable. And as I say, the first point I would pick up, sir, would be the elevated siting. Well, to me, the applicants have explained quite clearly why they feel that this is necessary to have a somewhat elevated siting compared to the siting of the existing accommodation. But as I say, I'd welcome any comments from colleagues and yourself, or indeed Mr. Sutty, to the issues that I've raised.
I think I've a degree of sympathy with what you're saying, but I think that the unfortunate thing, and obviously I'll ask the rest of the members to contribute, is that the demolition of a house, the usual thing is for the same site to be used for a new building, but they're using the flattening of this house to justify building a house on another site, if you like, or another part of a larger site. And whether it would actually fit in there, I appreciate they're wanting more sunlight, and I just don't know what that house will get at the present moment. Councillor Thompson.
Yeah, I mean, I can actually sympathise a lot with the applicants and what they're trying to do. Clearly, the grounds for refusal are on the massing and the scale and how it will dominate the system. And in some respects, I think the applicants have addressed that, in that there are no objections, from the neighbours in terms of what they're actually trying to do. What they're trying to do is really produce a house that has certain benefits in terms of energy usage. And the reason I believe that they would want to move that is to actually gain, the maximum solar impact that they can. I'm not quite sure how we would go about dealing with that situation, and I would appreciate some advice perhaps from the planning advisor on what might be done on that.
Does anybody else want to comment before I bring Mr. Sutty in? Councillor Nicholl.
Yeah, thanks, Chair. I took the liberty of having a drive past. I know the area well because I was born and brought up in that area. And I had a drive past on Sunday afternoon just to have a look and get my bearings. And as far as I can see, the ground, the bottom of the house was going to start at roughly the same height as the new house that's there. The top of the ridge of the dormer windows, at least, of that new house. So it is pretty elevated. It is going to dominate the whole area. But I have sympathy with what the applicants are trying to do, because they are trying to make an eco-friendly house here, and one which is going to make most use of natural resources of the surrounding area, or of the atmosphere. So I have great sympathy with it, but it would dominate the area pretty, the whole small building group, if you like, of Anwoth, which is very historic and fairly old, very old.
That's right. We would probably support the principles, but the site's maybe not the correct one. Mr. Sutty, do you want to comment, please?
I think the only thing that I would draw members' attention to is that in the case officer's report on page 184 and 185, I noticed there were two comments. Firstly, in paragraph 4.6, she actually echoes many of the comments that I've heard from panel members here. It actually says this is welcomed in respect of the passive house principle. So there is support from the case officer to that, but then paragraph 410, I think, is probably the telling one, where it goes through what they're saying is this application is, the purpose of the report is not to predetermine a future application, but nevertheless sets out a number of suggestions as to what could be done. So that, from my reading of this, was actually put to the applicant, but then the last line says the applicant is advised that they wish the application to be determined as submitted. So that's obviously what the appointed officer did. That they determined the application as submitted as a refusal because of the nature, but obviously without prejudice to any future application, they are giving some clues there as to how they think it could be addressed.
Going back, sir, to paragraph 4.10 and to the first point, positioning the dwelling house within the southeastern part of the application site. Well, I mean, the applicants, have made the point in the report that they would need, if that were to be the case, they would need a sewage pump, as it were, to deal with that aspect of the dwelling. And it seems to me that is tended to undercut, to me, what they're seeking to achieve. One of the classic definitions, of course, of planning is that ultimately it's a matter of opinion. I see I think Mr. Sutty's grimacing rather than smiling, but at the end of the day, I mean, I have to say that I, personally don't feel that, were we to grant the application, it would dominate the whole of the small building group, as certain colleagues feel. But that's the whole point of having a review body. That,
Anybody else want to comment? Right. I've moved that we go with the recommendation. I suppose what we could do is suggest to the applicant, if we go with the recommendation, that we suggest to the applicants that get in discussion with the planners to seek a way around about this. We've got sympathy with our application, but not as planned.
Sir, were the LRB today to take the view that, notwithstanding the case officer's decision, we would wish to grant the application, the question would be, what would be the process to go through that? Now, I'm minded that very much at the last two meetings of the full Planning Applications Committee, we have asked for an adjournment, as it were, to discuss and to take professional planning advice. So let's not beat about the bush in that regard. I presume that would be a facility open, as it were, to this LRB today, if there was at least two members minded to do so. And I might be misreading Councillor Thompson's comments, but I think that, I certainly would like to explore the possibility of granting a consent, an appropriate consent. But again, you obviously would require to have sound, valid planning grounds for doing so. And that's really the thrust of my question.
I suppose we may be in a position where we refuse this and advise the people to come back and get in consultation with a view to a new design, and we may have to reject it, or can we defer it? Mr. Sutty?
Well, at the beginning of the meeting, obviously the clerk read out the various options you have. It is an option to uphold the original decision, i.e. to refuse planning permission, although actually having looked at the wording, I would suggest that if you do want to do that, you take another option, vary it, because I think there are some typos in there in the actual decision that was issued. This citing the design seems to be extraneous and probably shouldn't be in there. You can resolve to grant planning permission, and that can be conditional or unconditional. I would suggest that you probably don't need a deferment to hear me say that I think it's a fairly straightforward case. If you were wishing to approve it, the conditions would just be the standard ones, and you've got the papers, you've got the roads officer's recommended conditions C121, and then the standard directives in terms of the 5 years of it being 3 years as it's a full planning permission, the commencement of it, and a directive about Scottish Water's comments as well. So I don't think you actually have a need to defer or to go into a recess. That would be clear advice. It's a very straightforward case if you wish to approve. It is, certainly from my perspective, appears to be a very straightforward case. The principle of development within this curtilage has been granted by the council. It is within a small building group. It's solely to do with the actual proposed siting design, and it's a bit all or nothing. So that if you are minded to go with what you see before you, I would suggest that it's a straightforward process of just granting planning permission. If you have sympathies but consider that what you're seeing before you today is maybe not the most appropriate solution, then I think the correct thing would be to uphold the decision. Whether or not it is appropriate because it seems to be prejudging it to actually minute as part of that you would recommend that further discussions take place, but I can see that the applicants are here today, so they're obviously hearing your views in that regard.
Just a second, Councillor Gates, given they've already got planning permission for knocking down and replacing the existing building, it's placement and design we're talking about on this, so where does that leave us? Councillor Geddes?
Well, I'm grateful to Mr Sutty, sir, for his advice, as is invariably the case. I am of the view that we should in fact grant this application for planning consent, subject to the standard conditions as Mr Sutty has outlined. I don't know whether I've got support or not.
I would second that.
Councillor Mail, you want to comment? Yeah. You're quite happy to go that way. Councillor Nicholl, are you otherwise minded?
No, well, I mean, I have great sympathy with the people who are trying to do something that's right here. Unfortunately, unfortunately, in the planning officer's eyes, they want to do it in a different part of the site, which is elevated. There is no question about that. I don't think there's any. I don't think there's any great complaint about the actual design of the property. It's more about the siting on the site. And it will be higher than anything else round about it. Not taller than some of the other buildings, but it will be higher. So, but we're trying to encourage people to come and live in the rural areas, and we, you know, we need. When I consider some of the things that we've given permission for in Wigtonshire, this is relatively straightforward. So, Mr. Councillor Geddes might not agree with me on that one. I was part of the proceedings, Councillor Geddes. So yeah, I think I'm going to go with it. I think I'm going to grant. I would be minded to grant the permission, or to overturn the existing ruling.
And based on what Mr Sutty is saying about siting and design, that can be worked between planning and the applicant. Okay, everybody's in agreement. Claire, have you got something written down for that?
I do indeed. I can confirm that the local review body are reversing the decision of the appointed officer and are granting permission for Tamworth Lea, Anwoth, Gatehouse of Fleet, planning permission for demolition of existing dwelling house, erection of replacement dwelling house and detached garage, and installation of septic tank and soakaway subject to the standard conditions as outlined by Mr Sutty.
Thank you very much, Claire. Can we now move to the next notice of review, non-determination of application for erection of 4 semi-detached dwelling houses, formation of vehicular accesses and turning areas, formation of access road and public open space, approval in part of matters specified in conditions 3 to 6 of planning permission in principle, 12/B/4/0004, Halcrow Stadium, Annan Road, Gretna. Well,
Thank you. Again, I'll take you through the key documents that you have in your papers. You have the Notice of Review dated 25th of January 2013, report on handling observations of the appointed officers on the applicant's Notice of Review and related correspondence, the planning application form dated 5th of November 2012, and you have the photos of the application site and the locality. The grounds of refusal in this case are that the application has not been refused or determined in any way by the appointed officer, although it is regarded as a deemed refusal, in that the appointed officer did not make a decision on the application within the statutory 2-month determination period. The applicant has therefore exercised their right to effectively remove the application from the scheme of delegation to officers and requested that the LRB make the first decision on this application. A report, however, has been provided by the appointed officer for consideration by the LRB, along with observations on the applicant's comments. These can be found on pages 315 to 318. It is noted that the appointed officer is recommending that the LRB resolve to not consider the review due to the current ongoing legal action in the Court of Session. It should be noted that by not taking a decision within the statutory 2-month period, the applicants will gain a right of appeal to the Scottish Ministers. The requested method of determination on page 310 is that the applicant has requested that the review be dealt with on the basis of the assessment of the review documents only, with no further process. The grounds stated in the Notice of Review on page 311 are, in summary, that the Council did not determine the application within the statutory 2-month period, so the applicant has submitted a Notice of Review to the local review body. The applicant considers that the proposal is a modest scheme for just 4 dwelling houses as part of a larger development, which they consider has a grant of planning permission in principle and consider that there are no appropriate grounds for refusal. You have further comments of interested parties, being the comments of Development Team Leader Dale Nestdale, comments of Scottish Water, report of handling, comments of appointed officer. So the main issues for the local review body to consider are, given that there is ongoing legal action in the Court of Session regarding the status of the related application for planning permission in principle 12P4/0004, are the LRB satisfied that it would be legally competent for them to determine this application for approval in part of matters specified on conditions of that earlier application. So having outlined the documents within the members' papers, again it falls to the LRB to determine whether it has sufficient information to consider the review, and it's determined again that there will be no representations from any party here today. So again, the options for the LRB are that it can decide it has sufficient information before them to determine the review, and if it determines this case, it can approve the application conditionally or unconditionally, refuse the application either in accordance with the recommended reason or some other planning reason or reasons, or resolve not to consider the review. As this is a non-determination case, the local review body has a period of 2 months to determine the case. The notice of review was received on 25th January 2013, and today is the first possible meeting date of the local review body at which the case can be considered. If the local review body has not determined the case by 25th of March 2013, the power to do so is removed by legislation, and the applicant has a right to appeal to the Scottish Ministers instead. Whilst it is technically the case that the local review body has the option of requesting further procedures, such as a site visit, further written representations or a hearing. In practice, due to the statutory period for issuing the procedure notice, etc., it will not be possible to undertake such procedures within the remaining determination period available to the local review body for this case. This effectively means that if the local review body wishes to determine this case itself, it will have to do so at today's meeting. It will be noted that the applicant's agent has confirmed that he is of the opinion that the review can continue to conclusion without any further procedure. Again, an independent planning advisor is present at your meeting, here to assist. He has not had any involvement in the case, is not the case officer or the appointed officer. He is here purely to provide independent advice as needed on matters of planning policy, law or process to the local review body. So again, if members are clear, no further clarification is required. I will ask the Chairman now to lead the debate and for the LRB in first instance to determine if they have sufficient information before them.
I think probably on the legal part, Mr. Sutty, should we discuss this case now or should we defer it because of the legal issues that's ongoing?
Chair, the issue really is that you can resolve to do whatever you wish with it, but if you defer it, you're really passing the ability today to make a determination on it, because as Claire just read out, basically on the 25th of March, it comes out of the local authority's ability to determine the notice of review, and the right of appeal to the Scottish ministers goes in place. However, our clear advice to you is basically not to determine this, to resolve to not consider this review, for the simple reason that the whole status of this application is at question, and that is why no determination has been made on it. I would certainly say because of the legal proceedings which are still underway, it would cause problems to the Council's case if you were to determine it. So our recommendation is quite clear, just to resolve not to consider this review.
Gentlemen, on your hands, Councillor Geddes.
Well, I would agree entirely with that recommendation, sir, for obvious reasons. Standing at the matter is, already in the Court of Session. I have my own views, and I think it's singularly unfortunate the way that this issue has arisen. Singularly unfortunate. We have not covered ourselves in glory over this, but we are where we are, and I think we've got to get it resolved. It is currently, in the Court of Session, and I would have no compunction whatsoever, Chairman, in accepting Mr. Sutty's advice and recommendation.
We won't determine this non-determination for the planning permission at the Halcrow Stadium, Annan Road, Gretna. I'll just leave that to the side. Okay, Claire?
Yeah, thank you, Chairman. I can confirm that the local review body have decided not to consider the review for Halcrow Stadium, Annan Road, Gretna, in a non-determination of application for erection of 4 semi-detached dwelling houses, formation of vehicular accesses and turning areas, formation of access roads and public open space. Approval in parts of matters specified in conditions 3 to 6, planning permission in principle 12P4 0004, 12P4 0324.
Thank you very much, Claire. I have no other business, gentlemen. Thank you all very much for your attendance. Thank you.